the court to be aware that the defense is going to try to get the court during its own deliberation to go back and crunch numbers and talk about response times and all this type of stuff, when all the court has to do is look at the evidence, look at the video, listen to the audio, and watch those 3 videotapes regarding the statements of the defendant. Everything else amounts to how many angels can dance on the head of a pin. They simply make no difference at all in this particular case. Neither do reading dozens of textbooks and all of that clutter that they have introduced into this trial. Now, before we talk about the facts, let's once again review the law that we're talking about. We have the homicide in this case. Nobody disputes that. A homicide exists anytime somebody kills another person. Now, if that homicide is committed intentionally and knowingly, then you have a murder. You have a murder unless, for some reason, that killing has been justified. And in this particular case, just self-defense is defined as using deadly force against another when a person reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. A person has a right to defend themselves against apparent danger to the same extent as if the danger were real, but only if the apprehension of that apparent danger was reasonable under the circumstances. A person must also act reasonably in response to their perception of that apparent danger. Now, the state's case can be summarized under 2 critical premises. The first premise is that this defendant's apprehension of a weapon was itself unreasonable. He could not differentiate in what he saw, even though he interpreted it to be a gun. He could not differentiate whether or not it was a long gun or whether or not it was a little bitty pistol, in his own words. That, we submit to the court, by itself is not a sufficient basis upon which to take somebody's life, especially in the 1.5 seconds that he chose to make that decision. Secondly, the defendant had plenty of cover, both in terms of darkness and also the engine block of that SUV that he was crouched behind, and plenty of time to safely evaluate the situation to make sure that he did not create the tragedy that he has created. Therefore, his response to that apprehension of a gun was not reasonable under the circumstances. Certainly, any reasonable person, especially a certified peace officer, would not have shot and killed Yvette Smith under these circumstances. Now, let me speak a moment about the state's stipulation, because the court interjected something into the proceedings, I believe it was yesterday afternoon late, and I want to make sure is clear to the court and clear for the record. We have never stipulated that this defendant saw a gun. We have stipulated that this defendant thought they saw a gun. That's not simply a semantic difference. If we stipulated that this defendant saw a gun, that means Yvette Smith actually had a gun in her hand, which would have changed the entire dynamics of this case. What we have stipulated is that he saw something in his mind that he interpreted to be a gun, and we'll talk about that more, but it's that shiny, chrome-looking L-shaped object. All of those were his words that he uses throughout, I think, all 3 of those videotapes. Once again, when asked whether or not that object that he thought was a gun was a long gun or a pistol, he told the ranger, under no certain terms, he did not know. Now let's talk about the facts of this case. The important facts are the dash cam car video, which now has even more importance than it once did. The 911 call from Amy Vila, which is still important, but perhaps a little bit less so, and the 3 interviews of the defendant, all of which are very important. So let's start first with the in-car video and talk about what that will tell us. This is the chronological breakdown, State's Exhibit number 27. I'm not going to go through all the top part because it would, I want to get right to the point. At 44 minutes, between 30 seconds to 32 seconds, is where this defendant says, "I can hear nothing from outside." As the court recollects, he is crouched behind the SUV at that point. I think he's towards the rear of the vehicle, and he eventually moves forward towards the front of the vehicle. Takes him approximately 2 seconds to say that. That's why we've got the hyphenated portion in our timeline. At 44 minutes 33 seconds, which is 1 second after he says those words, we can hear the sound of Yvette Smith opening that door, which has a loud noise to it, as we know from the witnesses that have testified. Now, we can't see this, but we can hear this. Then, 1 second later, is when, at 44 minutes 34 seconds, is when this defendant pops up and yells the word "police." He admits that in his statement. He thinks he says the word "sheriff," but he actually says the word "police." What makes that so important is he says on more than one occasion in his statement, at the time he says the word "sheriff" or "police," he was not in fear of his life at that point. In other words, no weapons pointed towards him. There's nothing to make him afraid for his life. Between 1 second and 1.5 seconds later is where he discharges his firearm. And then, of course, a few seconds later, after that, he says on the radio, "Suspect down." Now, we're not going to try to break down the science and talk about fractions and hundredths of a second as if we're in an NBA basketball game and this is the last shot. We don't care about that. That simply is not important. That, we would submit to the court, is simply a rabbit trail. The question is whether or not these times, and the court can see them whenever it reviews the videotape, gives this person, this defendant, a reasonable time to make a competent and complete evaluation under the circumstances. And we submit that that is certainly not reasonable for a law enforcement officer, and we'll talk about why here in a moment. First of all, when Yvette Smith stepped out onto that porch, this defendant was expecting Chris Thomas. He may not have known his name, but he knew that there was a large male coming out. He expected that large male to have a gun because of the reports about somebody standing behind the door with a gun. It wasn't a large male, it was Yvette Smith who stepped out, who did not have a gun. Now, we all know that the lighting was very poor in this particular case. Both defense brought that out, and so did the state. There's 40 feet of difference. The only lighting, really, substantial lighting, comes from the defendant's own flashlight. We also know that the defendant was not wearing his tactical glasses, what Megan and Hannah called his Batman glasses. We also know that he admitted to those two individuals that he suffered from night blindness, and they even talked about specific instances when they were on duty when that night blindness caused him to have problems during his training. We also know that prior to him being in this position, he had an opportunity to go back to his vehicle, which he did when he picked up his AR-15 rifle it would have been very easy, would have been very reasonable for him to grab his glasses so that he could better see what it was he was looking at, but he chose not to do that. We also know once again that he was in a place of almost complete safety. Yvette Smith didn't even know where he was at because he was hiding behind this SUV. He was wearing a bulletproof vest. We know that he could have taken, in that situation, as much time as he needed to be absolutely sure that this bright, shiny, chrome L-shaped object that he thought he was seeing was in fact a gun. Now, we don't know what it was that caused those images in his mind. We're not doubting that he had those images in his mind. We don't care what the cause was. It doesn't matter. The primary point of the state's case is that he had plenty of time. He didn't know himself what those images are or were. He merely made the inferences that those images referred to a gun because that's what he was expecting to see in Chris Thomas's hand. Once again, Your Honor, he had plenty of time to respond by taking a careful look, taking a second look, taking a third look if he needed to. He could have given commands, dropped the gun if he thought she had a gun. Or he could once again have moved around. He could have observed that situation for as long as he needed to before he ended Yvette Smith's life. He didn't have to pop up and expose himself. We know that if this defendant had done the simplest of those things, we would not be here today and Yvette Smith would be alive. Now let's talk about what the 911 tape tells us was going on the inside. On the inside, we can hear background voices. We can hear Yvette telling Chris to put the gun down. You're not in your right mind. That tells us Yvette Smith was being the peacemaker. She was trying to get Chris, who was probably intoxicated, but at any rate, he was acting irrationally. He had picked up his shotgun, might have been loading it, might have been unloading it, we don't know, but he had it in his hand, and she was trying her best to make sure something bad didn't happen. After she finally got Chris under control, Chris sat down on the couch. She goes to the door to check on Willie, because she doesn't know what Willie's doing outside. She knows that Willie was upset as well. That's when she steps outside. That's when her life was ended. We also know that the gun that they were fighting over from the 911 tape got placed on the table. You've got the res gestae statements, which, as the court knows, are among the most trustworthy of all types of statements that proves that fact. Now, what we don't know from the 911 tape, we don't know, again, whether or not Chris was actually loading or unloading that 410. We don't know that, but quite frankly, we don't care because it's not relevant. We don't know if the 410 was loaded or unloaded at the time it was placed on the table. We assume that it was unloaded because that's how it was found, but once again, it's irrelevant. We don't know who picked up the gun first, whether it was Yvette trying to keep Chris away from the gun or whether Chris grabbed it first. We don't know, but once again, we don't care because we know where that gun ended up. Now, let's talk a little bit about what the defendant said in his statements. In other words, his state of mind. We do know, regardless of what their experts have said during this trial, that this defendant is predisposed to think in tactical terms. It doesn't take anybody with expertise to watch that videotape, listen to the language he uses, watch the movements that he makes to conclude that he thinks in tactical terms. We also know that he was not thinking particularly rationally during that period of time, and I'll tell the court why. But he was, and I love the phrase that he used, he was narrating fictitious events in his own mind. We know that because almost everything we heard from him about what he was saying about Yvette Smith is factually impossible to be taking place. He described her as being wide-eyed. Now, we're talking about somebody 40 feet away in the dark who he observes for just a matter of a couple of seconds. There's no way in the world he could see her eyes. Now, why would he say that she was wide-eyed? Why would he say that she was catatonic? Catatonic means you're standing motionless, stiff. He didn't observe her long enough to describe her as being catatonic. That makes absolutely no sense. He describes her right arm as if it's holding something heavy. He can't see what's in her hand at first, but he says it's stiff as if it's holding something heavy. Once again, there's no way that he could have seen that in that short a period of time without his glasses in the pitch darkness. Also, if you will go carefully, either by listening to the video or by going through the transcripts, you'll hear a number of things, movements and so forth, that he ascribes to Yvette Smith that could not possibly have all happened in that short period of time. He says that Yvette steps out of the house. He says she's already turned 2 times. She indexed this imaginary gun at least twice. And by indexing, he's talking about bringing it up into a shooting position from down below. He says that she points the gun at gas cam. We don't even know for sure that he knows the gas cam's there. He says that she jumps back. She turns again. She steps out. Then defendant has this grainy and weird movement. She rotates the imaginary gun and steps back into the house. Defendant flashes his light the first time. She turns away for a moment. She starts to bring the imaginary gun up again. The defendant lights her up again and these are his own words, I'm sure it's an expression, for a split second. She moves away more. Then she begins to bring up the imaginary gun once more. Then defendant shoots. There's no way in the world all that could have happened in that second to second and a half period of time. Another interesting thing that you will notice when watching those 3 interviews, this defendant indicated absolutely no remorse for what he did on that scene. He never asked the ranger anything about, well, didn't you find a gun? He never expresses any concern for Yvette Smith, for Yvette Smith's family, or any acknowledgement for the tragedy that he has created. The only thing that he said of significance regarding that is that he said his first thought when she fell and hit the floor is, quote, she fell like lead. That was his thought. Not, oh my God, I may have killed somebody, but she fell like lead, as if he's in a video game. Putting all that together, Your Honor, what we know with absolute certainty about this case is that if this defendant had exercised proper judgment, we would not be here today, and Yvette Smith would be still alive. Let me take a moment to say a couple of quick things about their experts. Mr. Pfeiffer will speak more about Mr. Blake's testimony, but let me remind the court what Mr. Blake said towards the end of his cross-examination when I asked him why he never mentioned in his 50-some-odd page report the fact that this defendant was behind cover. He said in his opinion that was not even important. That, Your Honor, is an incredible statement, not to be believed. From his website, however, was something that I asked him about that was very interesting. He posts a very nice website with a blog on it that gives information and gives advice to other officers. And he's talking about officer-involved shootings. And he gives this recommendation. He recommends the following, and I'm going to quote his website exactly. He recommends in those situations, slowing down, keeping distance, assessing the situation, de-escalation, and making appropriate decisions. He goes on, and I quote, "The takeaway is that everyone involved in the criminal justice system is speaking very loudly, and agencies must listen." I would submit to the court, not just agencies are listening to what this court does, but the entire society is listening to what this court does. Now, Dr. Bailey testified. He's a psychiatrist, very honest man. I enjoyed listening to his testimony, but quite frankly, this is not a competency or a sanity trial. What he said simply didn't shine any light on this case whatsoever. In fact, Dr. Bailey himself admitted that this is not a psychiatric type of decision for the court to make. Why the defense decided to call him, I honestly do not know. Now, in contrast to those two experts, the state called Jonathan Priest, and of course we call Ranger Brina, who is also an expert in these types of cases. And if I can compare Jonathan Priest and Ranger Brina to Mr. Blake, our two experts have actually worked these cases. Our two experts, in the case of Jonathan Priest, has actually been involved in these types of cases. Mr. Blake has done a lot of reading about these kinds of cases. That's the difference between those two. But they boil this down, both of them, in very simple terms. They didn't try to dodge this forced silence, but they did not try to hide their case behind it and their opinions behind it either. They said exactly the same thing that we have been saying, that this is a very simple case, and that this defendant, when he saw those images, those L-shaped object images, simply did not know what he saw and should not have relied on that to take somebody's life. He had plenty of cover, they said, to evaluate and reasonably take the appropriate action. And they both opined that if he would have done so, Yvette Smith would be alive today. Your Honor, let me close by making a couple of remarks about political correctness, because I think it is important to this case. We know that it's difficult to convict a law enforcement officer for any kind of offense that they perform in the line of duty. In some political circles, it would be politically incorrect to convict a law enforcement officer for anything they did, regardless of how egregious the crime. In fact, we saw some of that sentiment expressed in our first trial during jury selection. In other political circles, any cop who uses his gun in the line of duty to have to shoot somebody should be considered guilty, even if that shooting turns out to be totally justified. We believe that we saw some of that sentiment as well in that first trial, but we would urge the court to realize that both of those extremes are misguided and are damaging to our society. It's like an umpire in a baseball game. That umpire is required to call strikes fairly and accurately, even if these decisions on balls and strikes goes against the partisan home crowd. If the umpire doesn't call balls and strikes correctly, if the game is not officiated correctly, both sides lose, because the game will spiral out of control and the fans simply won't want to watch the games anymore. The same thing holds true in these types of cases, Your Honor. In order to preserve the integrity not only of the criminal justice system, but on behalf of law enforcement, on behalf of the 99.9% of the law enforcement officers that are going out there honorably and doing their job, facing whatever dangers they have to face, and doing the right thing. They want to make sure that their profession is purged of what David Blake says on his website are these rogue cops or bad actors. Now, we realize that murder charge is hard to wrap your head around on something like this because we don't have malice. We don't have premeditation in the long-term sense. We don't have the typical types of motive in this type of case. And since this is a bench trial and not a jury trial, I think I'm entitled to tell the court that I researched the law for a great period of time before trying to decide what charge to bring in this particular case. I looked at manslaughter. Manslaughter requires a reckless state of mind or a reckless intent. Criminally negligent homicide requires a negligent intent. Here the evidence is undisputed that this defendant, even though his train of thought might have been reckless, his train of thought might have been negligent, nevertheless his decision to shoot and kill Yvette Smith was intentional and knowingly. He even mentioned that when he was taking aim, he aimed for center mass. I looked at the crime of deadly conduct, thinking that might be a good fit. It's certainly a lesser crime than murder. Unfortunately, there's a line of cases coming from the Court of Criminal Appeals saying that deadly conduct is not an appropriate charge whenever there's been an actual injury or death involved. It's the type of facts that would fit deadly conduct is somebody shooting into a crowd but doesn't actually hit anybody. So, Your Honor, murder is the only charge that the state can bring in this particular case because it's the only statute, the murder statute is, that fits the facts. We would like nothing more for the legislature to write a law that covered law enforcement police officer shootings, to make it a separate type of crime, its own category of crime, and design the proper types of punishments. We would be happy with that, but we don't have that. This is the only charge, Your Honor, we can bring. Now, at the appropriate time, the court can, of course, consider the second-degree murder if the court considers sudden passion and adequate cause to be factors in this case. But it's still murder. It's still the way it's defined under our law. Your Honor, we feel like this case, in that our society does not believe that wearing a badge and taking an oath to protect the public is a license to kill. And that's what the direction is with some of the people that would like law enforcement to get away with any type of action that they do, if even the egregious actions when they're on duty. To be a peace officer means that you're supposed to bring peace to any situation that you encounter. They're here to protect us. Now, we realize that the days of Andy of Mayberry are no longer valid, but we are also not in a time where being a RoboCop is appropriate either. Yvette Smith was a kind and gentle woman, Your Honor. She deserved better. She deserved more consideration from this defendant. She deserved a law enforcement response that was responsible and was reasonable whenever she walked out on the court. She did not deserve to be gunned down. There is no justification for her death, Your Honor. And even though these types of cases are difficult, they're the type of cases that scream for some sort of consequence there must be some sort of message sent not only to this defendant but to our entire public that there is a line that cannot be crossed. This case crosses that line, Your Honor. All we would ask the court to do is to look at the law and apply the law to the facts of this case.
Thank you, sir. You may adjust that as you need.
Thank you.
You may proceed.
Thank you. What we've just heard, Judge, is several pleas, but a blatant disregard for the actual legal standard in this case. The prosecutor just spent a large amount of his argument talking about he'd like the legislature to make a new law, and he would like you to consider the political aspects of your decision. It even tried to imply that somehow this is about society and what society wants, what we expect peace officers to do. That's not the law. He actually stood here and said that a scientific analysis of this case was a rabbit trail, that you should disregard human science factors, that you should disregard the medical field and psychiatry in analyzing this case. I mean, he actually wants you to convict someone of murder because they weren't wearing their glasses. I mean, that's how far we've gone here. And you want to talk about a rabbit trail. This whole night blindness thing is a rabbit trail, and Dr. Bailey, the only medical doctor who testified, put that to bed quite sufficiently. But he's asking you for a new legal standard, and in all of his argument didn't even acknowledge his burden to disprove self-defense beyond a reasonable doubt. And let's talk about what the actual standard is. The standard is whether the actor reasonably believes force is necessary to protect the actor against the other's use of unlawful or attempted use of unlawful force. And as the court is aware, the reasonableness is viewed from the actor's standpoint. And as I said, the state is required to disprove self-defense beyond a reasonable doubt. The law of apparent danger, as the court is aware, applies in this case. And paraphrasing that law, the doctrine of apparent danger states that if the actor has a reasonable expectation of fear or death, he is allowed to use force to protect himself, whether the danger was actual or apparent, provided the apprehension of danger was reasonable. What the state wants you to do is I guess, legislate a new law that says that getting rid of apparent danger, apparently, and saying that all police officers must wait. That's not the law. And what's so interesting is that the state has stipulated to self-defense and apparent danger. The prosecutor spent some time trying to explain away his stipulation, but I asked that your court reporter, Your Honor, to print out the stipulation so we could read it to the record. She was kind enough to do that for me yesterday. And I'll quote from the record. The state will stipulate that in his mind, for some reason, he thought he saw a gun. That's apparent danger. If you're a police officer and you have gone to what we all know was an extremely volatile, dangerous situation where people are drunk and fighting over loaded gun, danger. They've agreed to that. The ranger also testified that he thought that Daniel Willis had a gun. Their own John Priest testified that it was reasonable for Daniel Willis to believe that Yvette Smith was accessing a weapon. John Priest testified, and I wrote it down so I would get it exactly right, that he absolutely believed Daniel Willis was expecting to see a gun based on what he had been told by dispatch. Why are we here? own witnesses testified in fear of his life. That occurred in this case, and I thought it was interesting that the prosecutor says that we know a lot about what happened, but we don't care. Well, this is a murder case, Your Honor. We have to care. We have to care about all of the circumstances that were going on in this case, especially when the law of apparent danger applies. And he said also that he didn't want, we could just disregard whether or not the gun was loaded. We could disregard, what this person was thinking, this person was doing. No, we can't. We can't. We absolutely cannot. That's why we have a trial. That's why we have the law of apparent danger. That's why we have the law of self-defense. We are to consider this fact. I understand why he doesn't want it, but let's go through it. This was the second call to 911 to the same location for a violent offense on the same day. And I remember during the trial, as I'm sure the court does, that the state tried to portray this as there was nobody there that had any action towards law enforcement. Somebody ran over another person in the car. Children on the porch. That's not a law-abiding act. Those aren't people that respect the law. On the 911 call that Daniel Willis responded to in the early morning hours of February 16, 2014, we hear Amy Vela crying and hysterical. But we also heard that Amy Vela wasn't the only one who felt it was necessary to call 911. Willie Thomas, through his phone to Yvette Smith, she dialed 911, and Amy Vela made the call. They all three thought it was necessary to call 911 to request law enforcement help for the danger that they were engaged in. All of the officers responded code 3, lights and sirens, to a call of domestic violence with two men fighting over sledgehammers. Dispatch reported a fight over sledgehammers between two drunk males, a struggle over a gun inside the house, that the gun was being loaded, that there was a man behind the door with a loaded gun who was going to handle his business. And, Megan Burst testified, well, she said she agreed that when she talked to the ranger, she thought that when she got that information that there was a man behind the door with a loaded gun, she thought he was going to go out and shoot her officer. It was such a dangerous situation that she stopped doing her job. She stopped reading the call card and started focusing on what was going on. That's danger. On the 911 call, Amy Vela, as I stated, was hysterical and crying, saying, "Please hurry," 9 times. She hid from her own boyfriend because of his emotional instability. She hid from the person that she was in a romantic relationship with and she agreed loved at the time because she was scared of him. She didn't even want to know she was on the phone with 911. She hid from her own boyfriend. She testified that she was scared for her life and everyone else's. Deputies Hurtado and Yarborough thought that the call was so dangerous that they dispatched themselves. They didn't even wait for dispatch to say, "Go out there, you need to back up." And in fact, Yarborough testified that he drove as fast as he possibly could because it was an emergency situation. Both Deputy Hurtado and Deputy Gascamp grabbed their rifles because, as Hurtado described, anything could happen. Anything could happen because there was a firearm involved. They both jumped in their rifles in preparation of a dangerous situation. All of the officers described the scene as high stress, chaotic, high risk, emergency, rapidly evolving, and escalating. Remember what Dr. Bailey said yesterday. When you have a response as a police officer, you're not allowed to flee. It's only fight. You have to run head first into danger. Ranger Barina testified that Daniel Willis thought he saw a gun because he expected there to be one based on what dispatch told him. Ranger Barina agreed that hands are the most dangerous part of the body and that Daniel Willis could not see Yvette Smith's hands. David Blake testified that all the parties involved expressed fear according to his review of the case. Everybody was scared. Why does everyone else get to be scared except Daniel Willis? Megan Birch thinks somebody's going to shoot somebody, but Daniel Willis doesn't get to? Dr. Bailey testified the situation was extremely volatile and that Daniel Willis was in fear for his life when he shot Yvette Smith. In fact, every witness that testified stated that the scene was dangerous. There wasn't one person that said it was dangerous. That's apparent danger. That's self-defense. On top of what everybody else said, there is evidence replete in the record that Daniel Willis expressed fear for his life. On his dash cam video, you can hear him telling Sergeant Davenport, "I didn't want to die," earlier. Daniel Willis told Ranger Barina repeatedly that he was in fear for his life and that he saw a gun. That never changed. They can suppose all they want in a third interview after Daniel Willis's memory of the events has obviously been filled in with gases the brains like to do, and they can cast doubt on that. They can say, well, he said he might have saw this or he might have saw that. We read the transcript twice yesterday. He was very, very clear. He saw a gun. That is apparent danger. That is self-defense. And I found it very interesting that the ranger tried to adapt this new standard yesterday too about we should all just wait, we should all just wait. That's not the law. I couldn't believe he said that. That is not the law. When you are a police officer and you encounter apparent danger, you are trained to eliminate that threat. Daniel Willis, immediately after the shooting, is heard on the dash cam video when Chris Thomas and Amy Vela are yelling at him, saying there wasn't a gun when there's 5 guns inside the house, and they had been fighting over a gun. He testified that, he said on the video that she had a gun. I saw a gun. That's at the scene immediately after the shots. That's self-defense and apparent danger. David Blake testified that, based on science and the way the body reacts and physiology, that he thought Daniel Willis was in fear for his life. I don't understand why we would ignore science in a case of this magnitude. Dr. Bailey, a forensic psychiatrist, testified that Daniel Willis was in fear for his life. He's a psychiatrist and medical doctor who actually examined Daniel Willis. He's a nationally renowned psychiatrist professional who teaches others in his field. He read every document in this case. He watched every video. He listened to the audios and he examined Daniel Willis and gave his opinion. Reasonably that he was in fear and he used deadly force. And if that wasn't enough, on the dash cam video, you can see right before the shots are fired that Daniel Willis ducks before he fires the shots. You can't plan that. Clearly, he was responding to a threat. And I think it's insulting to say that to try to characterize someone's duck as efficient or inefficient. If you're in fear, your body reacts in a way that you have no control over. Daniel Willis saw a threat and ducked. He even wants to criticize the way he ducked. Daniel Willis, the evidence has shown, acted in self-defense. There was apparent danger, and he reacted as he is justified to do under the law. A lot has been said about, or brought into contention about the reasonableness of that conduct. And so I'm going to turn it over to Mr. McCaig now and let him address reasonableness. But I will say, Your Honor, without a doubt, the state simply has not disproved self-defense beyond a reasonable doubt.
Your Honor, there's no doubt, none, that Daniel Willis's conduct was objectively reasonable. And to add to what Ms. Jernigan did a fine job of discussing the dangerous situation, the confusion and uncertainty that happened. Keep in mind, the state's own witness, Ms. Hannah Gardner-Perry, was asked, was Deputy Willis there to defuse a situation that these people had created at their house? The answer was yes. Daniel Willis was not some rogue, out-of-control RoboCop that was off-duty, running around with an automatic rifle looking for trouble, looking to interject himself into people's lives. No, he was there at the request of people, 3 people, who joined together to call 911 begging for his help. A situation that was created in their home. Let's not forget the failure of the Bastrop County dispatcher. Ms. Burrs can get on the witness stand and she can blame the CAD system, and she can say I quit reading the card, and she can say I never heard it. But the fact is that there's information relayed in Yvette 911, and shotgun had been laid down on the table, and Daniel Willis did not get that information. And somehow, Daniel Willis, somehow that contributes to why this man is sitting here trying to murder. But what do we know that Daniel Willis did do? What we know about Daniel Willis that's how dark it was. Pitch black. Dangerous. He got people out of the house. And as Ms. Jernigan, he immediately science, the testimony testified to, that he was Ranger Brandon's assistant. Mike Daniel formed no independent conclusions. And Dr. Bailey's testimony was the same class and had a certificate. But somehow, we know the officer would testify to that and have this case. We know that Daniel Willis was not out of control. He did exactly what his training is. he shot at center mass, and he fired only 2 rounds. At the time, may have taught them 2 shots to the body and 1 to the head. 2 shots, center mass. He had 28 rounds in a magazine, extra magazines, and 2 additional firearms, and he didn't access those. He fired 2 rounds and stopped. He fired a round, got a second sight picture, and a second round. Those are stopped the threat. He shot, the threat was stopped, and he stopped. And with a second of shooting, what Daniel Willis do? He called down, sending other units and EMS as well. He got people out of the house. And as Ms. Jernigan pointed out, he immediately expressed his feelings at the scene. I didn't want to die. She had a gun. Consistent with Amy Vela, I was in fear for my life and everyone else's because I didn't know what was going to happen. It's a direct quote from her testimony. Everyone else's life. Daniel Willis was fully cooperative with this investigation, unlike all of the lay witnesses from the state. Willie refused to give a statement. Chris Thomas refused to give a statement. Amy Vela refused to give a statement or have her children interviewed. Ernestine Owens refused to give a statement. David Blake said it simply the best. In universal teaching to police officers, when you perceive a gun, you react. Daniel Willis was reasonable in following that training. He perceived the gun and he reacted. Ms. Jernigan points out, he ducked on video. That wasn't something he planned, like, do a fake duck so that I can later justify executing this woman when I'm accused of murder. That wasn't something he planned. That was a natural human response to having something pointed at you. In this case, a gun. He perceives a gun, he ducks, and he reacts. Exactly what a reasonable officer would do. There's been a lot of discussion about the photograph that appears in this case. It's on page 30 of David Blake's report that shows through the front window a thick tabletop in a horizontal fashion at approximately waist level, covered with a plastic covering with an uneven surface, reflects. Could that have contributed to his armed these poor lighting conditions and the stressful, time-compressed environment that he was in? Absolutely. Could Yvette's jewelry? The medical examiner's report reflects that she had 2 rings on each hand, earrings. Could that have contributed to Daniel Willis's perception, the shining reflection, that she was holding a gun? Could those things together have happened? Science tells you yes. It's absolutely possible. Those are possibilities. The state wants the court to ignore the human factors element involved. 100 years of science cannot be and should not be ignored. The only expert in human factors that the court heard from was David Blake. Jonathan Priest admitted he was not an expert in human factors science, that he had only taken a 40-hour course. Ranger Barina admitted, at least initially this week, he was not an expert in human factor science, but rather that he had completed the same course, the same class, and had a certificate. But somehow, we know that David Blake was able to complete a 54-page report that had 7 separate experts. Couldn't have made a such report. Did he think of his opinions that he could back them without a report? Nothing to paper, nothing to back up his opinions. Agreed with 5 of them. With 1 of them, he said it was hard to say, and with of them, the seventh one, he said was prior to the testimony on the seventh. Somehow, Ranger Barina, even though he was so agreeable with David Blake and supportive of the science, he reached a different conclusion in this case. Science is on science. The testimony about science has shown the court these decisions don't happen in seconds. They don't happen in approximate times. They don't happen in should have waited a certain amount of time. People live and die in fractions of a second. Decisions are made in nanoseconds. And every fraction Brina even admitted that there the state wants to say, well, Judge, if he had waited 1 more second, 2 more seconds, 5 more seconds, 10 more seconds, what is the magic number? There's not a magic number. And the court has to give a great deal of different deference to Daniel Willis's decision to file, the inputs he was seeing at the time. Because action always beats reaction. And if you wait, you die. Based on science, the court now knows that easily within that 3.47 second time period that Yvette presented herself at the doorway, that Daniel Willis was able to quickly assess the situation and initially did not consider Yvette a threat, as he told Ranger Brink.
Thank you very much. Sir, would you leave the courtroom with your phone? You may continue, sir.
That Daniel Willis was able to yell police, that Yvette made physical movements, including pointing what Daniel Willis perceived to be a gun directly at him, that Daniel Willis formed an instant fear for his safety based on this new information of a threat being fed to his brain, and that he fired his rifle to stop that perceived threat. All of those things easily fit in 3.47 seconds, based on science, based on 50 to 100 years of studies and research, as David Blake pointed out. And that based on all of that testimony, David Blake told this court that Daniel Willis's actions were objectively reasonable. Even if the court takes what Mr. Sanderson said as truth, that David Blake preaches on his website, distance, patience, delay, whatever he said. Even if he sees things through that light, David Blake's opinion in this case was still that Daniel Willis's actions were objectively reasonable. Dr. Bailey's testimony was absolutely relevant. He even said 20/30 vision is, quote, fairly normal. There's been no diagnosis of night blindness in this case, and that's based on medical records obtained by Ranger Brent Barina. We know that fear forms in an instant. We know that Daniel Willis had no premeditated intent to do harm. There was no preemptive execution, as the state wants the court to believe. But this was preemptive violence by the police. We know that Willis believed he saw a gun. And the prosecutor even said yesterday that Dr. Bailey was, quote, in the best position to evaluate Daniel Willis's mental state. And Dr. Bailey being in the best position to evaluate Daniel Willis's mental state, the opinion was that his actions were objectively reasonable based on the totality of the circumstances. The best witness says those things. It is relevant that we have a subpar and a bias investigation in this case. Ranger Barina misled this court in believing that Mike Daniel conducted an independent parallel investigation to his. And that is not what Mike Daniel testified to. That he was Ranger Barina's assistant. Mike Daniel formed no independent conclusions and did not have the opportunity to testify at the grand jury. What's the state hiding in this investigation? Well, they hid Mike Daniel, but we got him here. Measurements weren't taken? That's expected. How many times did Jonathan Priest use the phrase that they did not follow what he termed as best practices in their investigation? A dozen? 2 dozen? 3 dozen times? A scale diagram of the interior wasn't taken? In fact, the hand-drawn diagram is not an accurate reflection of the interior of that house. And it is relevant when it comes to where a door is placed as to whether someone can see what they claim to have seen. With Amy Veller, could she see what she thinks from her position? The answer is no. The diagram is not accurate. The photographs do not accurately reflect the scene. Nothing was done to test the light source from Daniel Willis's weapons light, to test reflections. No video was taken. The choice not to bring this evidence was made by the state of Texas. The state could have brought this evidence before the first trial. They could have gone out and gotten this evidence between the first trial and the second trial. They made the choice not to bring to court that evidence. They have failed. The officer knew at the time he acted. What's the difference between the term "at the time he acted" versus what the phrase "the state" falsely believes this court should use? How many times did Forrest Sanderson stand here and say, "What we know, ... what we now know, ... That is not the standard. The Supreme Court, in its wisdom, stated, quote, "We must give allowance for the fact that the police officer is often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving." Page 396 to 397 of that opinion. Daniel Willis did not know anything about the people's intentions inside the house. Daniel Willis did not know where the danger was. In fact, when the dispatcher asked Amy Vela who was going to hurt my officer, who was going to hurt, Amy Vela did not respond. And how is Daniel Willis supposed to feel safe and secure with that knowledge? The state wants this court to set a new standard by judging the result. Was there actual danger? The state wants to judge the result using hindsight vision. Evidence such as, well, we now believe she was unarmed. She is a good, peaceable person who would never harm a fly. That's their standard. That's the false standard. That flies directly in the face of 27 years of case law supported by Graham versus Connor. It is the opposite analysis the court should give. Simply put, we have 3 branches of government, and without any expert testimony from the defense, there are too many unanswered questions. There are too many holes. There are too many question marks to convict Daniel Willis of the offense of murder. However, in addition to pointing out these deficiencies to the court, the defense has gone beyond that. We have defense through not only the facts and evidence, also through the credible testimony of expert witnesses David Blake and Dr. Ron Bailey. And quite simply, the prosecution has failed to disprove self-defense and apparent danger beyond a reasonable doubt. They have failed in that burden. The state has failed to meet their burden of proof, and the court should acquit Daniel Willis of any criminal wrongdoing in this case.
From the state. Thank you, Arthur. You may proceed.
Thank you, Mr. Police Court. Thank you for the honor these minutes in front of you, representing the people of the state of Texas in this case. The people of the state of Texas includes not only Daniel Willis, Yvette Smith, or their families, or friends, but all of us, maybe most importantly of all, our children. Because this decision will set a standard. Forrest Sanderson was accused of asking the court to disregard the law and the correct decision based upon what the law should be as opposed to what the law is not. That is not true. I always feel kind of silly making an argument to the court about things the court had just heard, or things the court's heard over the last 2 or 3 days. You know the facts. You've heard the evidence. You've heard the argument. The evidence is available. It's certainly presumptuous to think that I or any attorney can tell you what the evidence is, what you remember, or what you remember, what you should remember, or how to apply that law, or apply those facts to the law of the case. And expert witnesses, their testimony is allowed under the law as to help the court assist the court, things the way the court says a lot of times, and the other courts says a lot of times, in making ultimate opinions, or arriving at ultimate opinions in the case. And that's, I guess, what these experts who made these reports, who have been put in evidence by the defense, say that those reports do. I wanted to come here today and talk about how we should summate the evidence. That's a word that used to be used back when I first started practicing law. We should make summations of what the evidence is. We should have a discussion over how the evidence is applied to the law. And the law is pretty clear. It's certainly known to the court. The court has charged the last jury we had, the jury we had the last trial, and what the law is stated in this case. The law is clear, and the court understands the law. And what the expert opinions that he says are uncontroverted by our experts, that their experts are somehow better than our experts. And that was actually an accusation he made to Verena yesterday. Their experts are not better, Your Honor. They have different experiences. Kind of like you remember when Dr. Bailey testified that they're psychiatrists and they're psychologists, and they both have opinions derived on certain things, but they come from different backgrounds, from different areas. That doesn't mean that psychologists have better opinions, or psychiatrists' opinions are found to be better. They come from different backgrounds, and that's certainly true of the experts in this case. I don't know how you can say that all of his years, all of these years, Ranger Verena was spent in law enforcement, actually working in these kind of situations, investigating these kinds of cases, or Mr. Priest, all of his years is somehow inferior to what Mr. Blake, I always made a mistake calling him Dr. Blake. He's not Dr. Blake. He's not a psychologist even. He is Mr. Blake, who's read a whole lot. And we recognize he's read a whole lot. He made a 50-page report, and a lot of it had to do with his qualifications, his background, his experience, his education. And I have no problem with any of this, Your Honor. I do have a problem with him taking this and comparing it to what Ranger Marina said and somehow say that his expert is better because he's read more books. And I have to comment about some of this, Your Honor, because it's just so blatant. His whole thing about 4.0 grade average in some online universities in California, to his work experience, most of which had to do with being employed as an officer for the Department of Energy contract, whatever that is, for 4 years. Most of the experience is doing what he's doing right now, Your Honor. Most of Officer Marina's experience is doing what his testimony is directed at, investigating crimes. Your Honor, sure, things could have been done better, perhaps, more thorough. You can always criticize people in hindsight, but you have the evidence in front of you. You have the evidence in front of you, and Ranger Marina, other law enforcement officers have brought you the evidence to make the decision. And they brought you sufficient evidence to make a decision, and it's uncontroverted. In fact, Mr. Sanderson was accused of somehow I don't know how to say this, accused of somehow twisting that around. I would like to take a few moments, Your Honor, to talk, I guess, to comment upon also the evidence that was admitted in these reports. Evidence from the testimony that I think the court indicated it would consider these evidence and these reports as the evidence. And of course, a lot of the reports, not a lot of it, is by definition hearsay. And it was offered not for the intent of just being demonstrative evidence. In fact, the argument of the defense attorney is that this is actually evidence. It's not hearsay. It is evidence. It is clearly hearsay. Not only is it hearsay, Your Honor, it's worse than that, because what Mr. Buck does, he states that he examines certain documents, he examines the evidence from this case, and he, based on literature he read, he opines these 7 opinions that he has, and of course his ultimate conclusion is regarding his conclusion that the defense attorney would like the court to arrive at. But that's not true. He also received input from the defendant himself. I don't know how he talked about one phone conversation. It could have been more than one conversation. That's his. He was allowed out of court, not under oath, after having months and months of time to think about things, to lobby this person into an opinion that he wanted to make anyway. Remember the thing about the photograph that is part of this report. That clearly is not proper part of this report. It's not, and it certainly is nothing more than just worse. Defendant Willis went out and took this flashlight, I guess on some sort of weapon. I don't know how it was mounted. That wasn't brought up. We don't know. He said it's 37 feet away. We don't know that. That's not in evidence. We said it was a flashlight that had the same illumes or could illuminate the same thing, or illuminate exactly the same his flashlight. If we don't know that, there's no evidence about that. We had no ability to cross-examine them about any of this and shine it against the wall. It's certainly not the wall that were shined against that night. So, and we don't know much about the wall even, or the other conditions, none of the other conditions. That is not in evidence, and that was not proper to be part of their report. It is hearsay. They're arguing today that it should be admitted for the truth of what's in the report and the truth of what's in, when there's actually makes it anything other than hearsay. And Dr. Bailey, Your Honor, we find him being honest with us, but he told you that not only did he examine all this evidence, but he also listened to the defendant for 4 hours in interviews. I guess I'm going to talk about 4 hours. I assume he gave his version of things, certainly months and months and months, not only after years after the events, but months after the last trial, months after anything else has happened, and also part of what he considered was the report of Mr. Blake. That is not only, I guess you call that double hearsay. That's hearsay on top of hearsay. And to hear the argument today as being some sort of message from above, the court is bound to follow, and the state has no rebuttal for, no irons for it, have no experience, validity, it should not be considered at all, is certainly what I can make, Your Honor. He gave Ranger Green a hard time yesterday by asking him about, had he read certain things? Had he read, and he was pointed specifically to page 12 of his report, to a study done by Ross et al. in 2000, and asked him, had he read that? No, I hadn't read that. And then he talks about, well, let's see what he says about what's in that report. What's in that study that Mr. Ross, or Dr. Ross, I guess, made in 2012. He said the study reviewed 1,100 lethal force case decisions from 1989 to 2012. They found that while events may have occurred after several minutes or several hours, quote, the average reaction, for instance, response time to shootings was less than 2 seconds in 90% of the cases. You may want to read that again, but it's hard to see what they're really saying here. Okay, so first of all, we disregard 10% of the cases. And we get down to the 90% that support the finding that in those 90% of the cases, the reaction time was less than 2%. Now, we have never told what reaction time even means. I guess reaction time, you put a stopwatch to it, it ends, you turn the clock off when you get to the shooting, when shots are fired. When do you turn it on? When does the reaction time start? When does perception start? When does your appreciation of events start? When does your evaluation start? When do you actually perceive the danger that you act upon? We don't know. We'll never know. What we have to look to is statements, the Ranger Marina, and we also have this video to look at, Your Honor. And we have to do what Forrest Sanders did. We have to correlate what's shown on the video, which we know to be true, what we think of what the defendant said over the course of 3 or 4 interviews. we don't even know which of those 3 or 4 interviews, according to their experts, which has more validity. I think Dr. Bailey said it could have been the first, or then on the other hand, it could have been the third. We keep talking about the core science it's not really that important to our case, or crucial. We say that we recognize this doctrine. We recognize the validity of this doctrine. We just don't see its application here as being determinative of anything. Going back to the study, so you discount the 10% that doesn't support your findings, and then you say that the average of the other 90%, I guess, was less than 2 seconds. What does average mean? You take 30 seconds, you have real fast time, and you take whatever's on the other side. We don't know what's on the other side. Let's say it could be 3 minutes, it could be 4 minutes, it could be 5 minutes. We really just don't know. That's fair. And whatever, you divide that by 2, and that is your average. And that's what we're talking about here. That's what I assume Dr. Ross is talking about there. Based on what Mr. Blake says. And this is supposed to be evidence to support their opinion. Look through all 50 pages of this, or at least look through the other pages that have these 7 opinions. All these 7 opinions are supported by what? Mostly all by events as related to Mr. Blake by the, I'll sort of say testimony, it's not testimony, of course, by the statements given by this defendant over the course of 3 interviews. Ranger Marina's never, I don't think you've heard me mention here. This is certainly a biased report that starts with an object defining reasonable actions for the defendant. It starts with that bias because that's what he was hired to do. And then he goes backward and he finds whatever he can and all these exhibits to support his opinion that he's already made, including things that are not even evidence and never will be in evidence. Said several times, of course, his trial, he cherry picks what he wants the court to consider. Of course, Your Honor, I don't think that you will cherry pick. I think you will consider all the evidence. And all the evidence is what Mr. Sanderson said. And, of course, there's a lot of evidence. There is evidence. But the irrefutable evidence is see in this video. The refutal evidence is this timeline, and we don't want to look at this. The timeline is relevant, but it's not. It doesn't. It's not an end all to things, Your Honor. It's not under different scenarios. Well, I don't really want to go into the timeline because I don't think it's the ultimate decision for the court to make as to whether or not all these contortions and everything that this defendant did fit within that timeline. The defendant chose to do what he did in the time that he did it. again, don't want to belabor things the court already is aware of. But some of these things, I think I have to say, there's no other way to characterize them other Sanderson talking about rabbit trails. When he talked about rabbit trails, it was in the sense that these are rabbit trails that were put there by the defense attorneys. This is part of their strategy. It's not something that the state put there. It's not something that we created. We're not advocating a new legal standard, Your Honor. We're advocating only that you follow the law, and we're not going to lecture you about what we think the law is. You know what the law is. And we on the stipulation a bunch of times, and you know what that stipulation is. I think you just read it in the record. It's not that the defendant saw a gun, it's that the defendant thought he saw a gun. Perception is not reality, perception is perception. Reality is reality. And all the evidence is that there was no gun and that there was not a reasonable perception. It was not a reasonable perception, and it was not acted upon reasonably. And that is part of the penal code, Your Honor. I appreciate the dictum that was read to you in the record about this United States Supreme Court, and I certainly would not ask that you disregard that holding or dictum in that case. But that was a completely different case. That was not the case applying the Texas Penal Code. And that's, of course, what you're doing here. That case was an entirely different case. You said, I'm sorry, Mr. Arnett said that science is on the side of Daniel Willis. Science is on the side of science, Your Honor. And I think you have to look at this science, that whatever science has been offered to you, not controverted, about what it says and not what it's meant to support. We have not objected to the introduction of that science into this case, Your Honor. We're saying that science doesn't always apply to what we're doing here. It doesn't apply to your decision, always. That science is not necessarily bad science, but what you'll be doing is deciding this case about what's in the penal code and not on what more science may have one to believe about the factors that were in Daniel Willis's head. We'll never know. We certainly know that it's affected by the stress, everything, but we just won't know that because of obvious reasons. There's too much disparity, too many statements, too much. We'll never know that. The objective evidence, Your Honor, in this case is what's in the video. And that video is corroborated by the statements in the report from this defendant. And there's much made about this movement that he made, whether or not that was a duck or lowering his head. And of course, we haven't talked about what purpose. There's other purposes for even ducking your head other than, it's more than just there's lots of reasons to duck your head, Honor. It could have been to assess the situation. We don't really know. But A movement is not necessarily a duck. Lowering your head is not necessarily a duck. That connotes something that's not necessarily true, but certainly not in evidence. There's been a whole lot of argument made about almost equating feeling fear as having reasonable fear for your life, and that simply is not true. We certainly stipulate, or not stipulate, the evidence is clear. He was scared. He felt fear, and sometimes that fear was escalating, and sometimes that fear was de-escalating. There's no question that he felt fear, Your Honor, all during this time. But at certain times, the fear de-escalated, as for example, when this person came to the door and it turned out not to be the man he expected, but this woman in a dress, and I think even Dr. Bailey testified that would be a de-escalating factor, not an escalating factor. And I think that the defendant, at some point in time, he makes a statement. At that time, I was not in fear. And I think that that's a statement to be believed. What for science tells us that under stress we confuse things, we put things out of order, we confuse time periods, we may have tunnel vision and focus on things that keep us from having a peripheral vision that would normally give us a bigger picture. But what Daniel Willis was talking about here was his feeling at a particular point in time, and that is not something that any of it shows that would be affected by this forced science theory. I think you can depend upon his expression of what his feeling was at that point in time, and that point in time was a big factor in determining where you began this reaction time to get to how many seconds you want to say that he had to respond to or didn't take in responding to this threat or perceived threat. Again, I'm sorry, you've heard this evidence. I don't want to belabor this, but there's been a whole lot of evidence about a whole lot of different things, and a lot of the evidence just is not relevant to what you'll be asked to decide, and that is the reasonableness of his taking this gun and shooting with intent to kill Yvette Smith. And that's the core question I think that you have to decide. And Your Honor, I think I will conclude by saying that all evidence is not equal. We talked about some things that would influence expert testimony. We've certainly given a lot of discussion about things that would influence human perception, that would cause witnesses and even defendant to say things that simply are not true objectively. Now, what we know is true objectively is what this video shows. And when Mr. Sanderson states that this case is simple, I think we're talking about the evidence being simple. The evidence being pretty clear-cut, not pretty clear. The evidence being as clear as you can make it. You know, if we had a choice, as you only had one camera to take out of that scene, knowing what's going to happen, where would you place that camera? on the front door or on the defendant?